something that you must appreciate is that mediation, most of them is 80% successful. As a mediator, once you've handled the process the way it should be handled, there's a most chance that 80% of the matters will settle. And 20% sometimes does not mean that you didn't do your job. Sometimes it means that the parties, for some reason, they don't want to agree, or maybe they prefer to, maybe for some reason, to use the other mechanisms of resolving their dispute.
Hi everyone, welcome to Mediator Talk Show. This is a show where we discuss about social issues that affect each one of us cutting across the economic status. Here we discuss about real issues that affect Hi everyone, welcome to Mediator Talk Show, a show where we discuss matters on social issues that affect each and every one of us, cutting across the socio-economic status. As I promised, I'll be bringing more informative videos, and today we are going to talk on a topic that is rarely talked about, and few people, if there is any, knows that it exists. I have a guest, an expert in that area. Today we'll talk about mediation. He's an expert in that, and I'm honored to host him. He was my lecturer. He trained me on matters mediation, and he's here to talk about that very important topic. I'll allow him to introduce himself, then I pick it from there. Karibu sana.
Thank you so much. Thank you so much. My name is Hesbon Peterson. I'm a mediation practitioner, that is. I'm also a mediation trainer. I'm a chartered mediator. Apart from once you trained as a certified professional mediator, you advance your skills. You have become a chartered mediator. And I'm one of the mediators from the court, what we call court-handled mediation, where matters from court are referred to mediation, to us now mediators, to help the parties resolve the dispute, which later we do a report to the court once the parties are able to agree. Yes, privilege has what I'll introduce myself as, among other very many aspects.
Okay, thank you so much.
Thank you.
Tell us the various ways to deal with dispute, and then you narrow down, you tell us what is mediation as one of the ways of dealing with disputes.
Yeah, we have very many ways in which we resolve our disputes, but most people know of let's meet in court, because they believe the court is the first point where the disputes are resolved, you know. But since time since our forefathers, there used to be disputes, and there used to be ways of resolving disputes. We used to have what you call traditional dispute resolution. You know, but now as we moved on, we have quite a number of dispute resolution mechanisms, what we call the dispute resolution spectrum, where we have litigation that is going to court is one of the ways of resolving our disputes. Then we have arbitration. Arbitration is a quasi-judicial process where now an arbitrator sits like a private judge, resolves a dispute and writes what we call an award, which is reduced into a judgment. We have what you call upmed. What that is, you start with arbitration, they go to mediation. Then you have a med up, you start with mediation, you go to arbitration. Then we have negotiation, we have conciliation, like what Kofi Annan did. Most people used to refer Kofi Annan as the mediator, but what he did was conciliation, where he came up with a solution and was guiding the parties towards that solution. And then now finally we have mediation, which is now we call the most preferred method of resolving disputes. Yes.
Okay. Explore more on mediation, because that is our main topic today.
Yes.
Yeah. Tell us what is mediation. Who can seek for the services of a mediator?
Yes.
Yeah.
Mediation, simply, most people do confuse mediation, meditation, you know.
Yeah.
But mediation is what you call is a facilitated process, or rather what you call assisted negotiation, where third parties are trained. Well, sometimes people say anybody can mediate, but I want to tell you that mediation is a structured process where now a third party is trained help the parties resolve their dispute. Mediators don't propose solutions. Mediators don't make decisions. Mediators help the parties by empowering them to make decisions which themselves can be able to live with. And so maybe I'll take you a little back.
Okay.
There are very many reasons why people fight.
Mm-hmm.
And usually what you say is people fight because of perceptions. It's perception that leads to a conflict. Because, for example, if I draw a 6 right here where I'm seated, I'll see a 6 because that's what from where I am.
Yeah.
Parties from the other side would see a 9, you know. But again, we say that who is right or who is wrong. Each and every person believes that they are right from their own perspective. The other person believes as such. So when you believe one party is wrong, and they believe you are wrong as well, that's now what leads us into a conflict. Perception. People perceive that they are right and you are wrong. No, that's now what leads us into into a conflict.
Okay.
And on that very same point, there's what we call again on the very same point of why people fight. There's what we call a retaliatory cycle. If someone says something, you are annoyed, then you respond back. You make it like a war of words.
Yeah.
Now nobody's willing to back. Nobody's willing to accommodate the other person's perspective. Now it turns into a fight.
Yeah.
Yes.
Okay. Take us through the process of mediation.
Thank you. Yeah. As I said, mediation is a structured process. It's not just another person's bringing people, sitting them down and trying to make them agree. It's a structured process whereby now the first point is where you meet the parties jointly. After you've secured their commitment to come to the table to negotiate, you meet them jointly. And just like another structured process, this is a process that has rules, or what we call ground rules, which guides the process. But among the simple rules that we use is that we request that the parties respect each other's position and even comments. That is, they should one party is speaking, the other one should not interrupt, and the speaking should be done through the mediator as a conduit of communication. Then again, this is a confidential process whereby parties must know, or they should be told, that whatever they are discussing within the session cannot be used against each other in the case of any further proceeding if they don't agree. And that even the mediator cannot be called maybe to court to be a witness or to make reference to what was discussed in the session. Another point is that the process of mediation is voluntary, and the process itself is non-binding. Nobody can coerce you or force you to stay in the session where you feel maybe the process is not going on as you thought or expected. So that's the beauty about this process. So in the first June session, what happens is you give the parties an opportunity to state to you what the problem is, or from their own perspective, what they think the issue is. And once you've been able to listen from each party, they have raised their issues. Now, it's at that point now you meet them separately, what you call a caucus, private sessions, where you can now to get more information from them, the information that they were not willing to share in the first June session, which you had jointly with them, and that you must promise them confidentiality, the process, that whatever we discuss here, we know as a mediator, I'm not going to disclose the other party unless you let me disclose that. Now, once in the caucus, in the joint session, what we do is we are trying to explore settlement opportunities, where parties are now from the issues which were raised in the joint session, where in caucus now they are trying to generate options to these issues which were raised. And now from there, now you go to the second joint session. Now we meet them jointly to try and now exchange the offers which were made. And at the end of it all, we come up with what we call as settlement or mediation settlement agreement. If they agree. And again, something that you must appreciate is that mediation, most of them is 80% successful. As a mediator, once you've handled the process the way it should be handled, there's a most chance that 80% of the matters will settle. And 20% sometimes does not mean that you didn't do your job. Sometimes it means that the parties, for some reason, they don't want to agree, or maybe they prefer to, maybe for some reason, to use the other mechanisms of resolving their dispute. Yeah, in summary, that's how the process works. Yes.
Well, actually, many people don't know that mostly we run to court. Let's meet in court.
Yes.
Unfortunately, I believe there are pros and cons associated with going to court and choosing to go for mediation. Take us through the pros and cons of choosing either of the channels. Yeah.
You know, mediation, what most people don't know is that mediation now it's in our constitution, the 2010 constitution, Article 159. Initially, I'll use in other terms, mediation is not an old, very old concept in the country, because actually even our courts, they started out the court annexed mediation in 2017, if I'm not wrong. So something that is not, let me say less than 5 years, where they started appreciating the fact that mediation actually helps in resolving disputes even faster. Now, the good thing about mediation, if I'll say about the advantages, for why I always encourage people to go the mediation way, number one is less costly compared to the cost of litigation or going to court, where you have to pay your lawyer, legal fees, filing fees, because you have to pay a filing fee in court, and there are many other costs which are incurred. Then another thing is less time consuming. Sometimes, through experience, you realize that you can solve a matter within one sitting, or even 2 sessions, the matter has been resolved. Unlike if you file a case, if you go to court right now to file a case, especially in these other courts like labor and environmental relations court, labor and environmental, employment courts, sometimes the next time you will get a date or mentioned date might be next year. You know, because there are a backlog of cases in court. Right now, if you go to court, there are a backlog of cases, and this one we every day, even from the Chief Justice, talked about a backlog of cases, and that there is need for parties or for those who want to litigate, there should be need for them to consider trying to resolve the dispute through mediation before proceeding to file it in court if it fails to settle that is. And then another advantage is that the mediation process is voluntary, in that you are not coerced into it, and that the process is non-binding. The process itself, that mediation process, you are not bound to whatever you say. But if you reach to an end and a settlement has been reached, now that is what is binding. That final document is binding, that can be reduced into a consent judgment and filed in court as a judgment, that is. Another bit about the process is very confidential, that whatever you discuss in the mediation cannot be used against you. Or even if you fail to agree and you go to court, nobody will say that he admitted this in mediation, and now why is he not admitting it here? That is expunged from record. Once you fail to agree, everything ends at that point. If you go to court, that's a different process. Now the normal litigation process will follow. Yes. I think basically those are some of the few advantages, but there are quite a number. Yes.
Wow. I know many people do not know mediation is there. And let's touch on family dispute or relationship. How is that handled when people come to mediation? How effective is that?
Yeah, thank you for that. And there are quite a number of mediation processes. Like I'll say there's family mediation, there's marital mediation, there's workplace, how to resolve workplace disputes. There's mediation in places of worship, that is in church, or even the mosque, we call it faith-based mediation. We have even mediating insurance disputes, mediating matters within that's not medical negligence. We have even what we need to appreciate that conflicts or disputes are never fulfilled nowadays. So now maybe to focus a little bit on family or relationship issues, there's a thin difference between family disputes and marital disputes.
Okay.
And especially for family disputes or family matters, maybe these are parties who have gotten a point where they want to part ways.
Yeah.
Maybe they had children,
Yes.
and now they want to focus maybe on how these children are going to be taken care of, that is the maintenance of the children.
Yeah.
We have how custody is going to be done, even co-parenting,
Yes.
because that is very necessary, and many others, even visitations. So what family matters are resolved in mediation. What is left is for the courts maybe to nullify the marriage now, because immediately you cannot nullify.
Yeah.
Yeah, and on the side of marital disputes, these are disputes for people who are married.
Yeah.
They have their issues. They have not gotten a point where they want to divorce.
Okay.
Because just like any other business or in a partnership, you have disputes among partners. That's the same that happens in a marital, where maybe a husband and a wife, they have differences. Maybe there are issues to do with how they're handling family business.
Yes.
Even nowadays people have joint accounts, and maybe
Yes.
there are issues about the same, and very many other issues. Maybe they are accusing each other of infidelity and very many other issues. So those are now marital disputes as well are resolved through mediation.
Okay.
Yes, and I always advise that that's the best line to use when you want to resolve matters, because there are a lot of emotions.
Yes.
And if you go to court, in a family court, you start crying in court or venting. It's not allowed.
Yeah.
You'll be thrown out. Maybe you're told now. The judges, they're not interested about the emotions.
Yeah.
But in mediation, parties can vent, they can cry, you can give them time, they release that energy, that angry energy within them, so they're able now to concentrate.
So someone watching there and you only believe in going to court, and especially matters pertaining family and focusing on children, and especially where now we have the co-parenting and all that. I would advise, not because of any value that it attached to it, but use mediation. Seek for mediation. Through mediation, there is privacy. There is you not spend more time like going to court, back and forth. Your parting shot, Mr. Hesbon. If someone out there who doesn't know, who only believe in going to court, justice through going to court.
Yes.
Yeah.
As a mediation practitioner, what I can encourage the general public, including families or those people in business, that mediation is the right way to go. That's the best way, because you are given the powers to provide solutions or to make decisions which you believe are best for your own interest. And like when now you go to court and you leave this at the discretion of a third party, who is a judge, to make a decision for you, to determine who is right or wrong.
Yeah.
In mediation, we don't determine who is right or wrong. We focus on the interest of the parties. Another thing I need to remind people is that mediation is, we don't focus about the law. We don't focus about the rights. Neither do we focus on fairness. We focus on the interest. People go to court with demands and positions. But when people come to court, they come with what exactly do they need and what are their interests. You realize that through mediation, your interests are better taken care of. And like when you go to court and a determination will be made, because nobody's assured of winning a case in court.
Sure.
You think that you have a strong case, but you'll be shocked that yes, you might win the case, but you have lost it. For example, sorry that I'm taking a bit far.
Yeah.
Is that if someone steals your property, let's say this bottle of water, they go to court. They have stolen it. You go to court. You pay a lawyer. You pay filing fees and any other costs which are involved. At the end of the day, you win the case. You give it back your bottle. You feel you've won, but you're forgetting that you incurred costs, meaning that's a loss.
Yeah.
So we feel that yes, you've won, but indeed you have all lost. Even the party who took it.
Yeah.
You use a lawyer, maybe they'll go to court, you have gained, but they have lost it. So nobody wins a case court. You win the war, you lose the battle.
Yeah.
You win the battle, you lose the war. So each and everyone is a loser when you go to court. But in mediation, you are able to reach a settlement, something that you're going to be able to live with, It might not be exactly what you wanted, but at least you've gotten something and you feel that, yes, I didn't get everything, but I think I feel like I've won. The other part feels as well that they win. It's a win-win situation, guys.
Wow.
Thank you.
Wow, mediation, I still continue advocating for mediation at the High Court that our people reconsider also not running to court but using other means to resolve dispute. Continue subscribing. Thank you for your support. Leave a comment, let's engage and get to know each other. And in case you need your case to be resolved through mediation, contact us. Our contact are just below there and we will link you up to the right professionals. Asante sana for coming, and from me and Hesbon, bye.
Thank you. Bye. Thank you.